The last case set for hearing today, or for argument, is State of Ohio versus Jeffrey Walter. The state has waived their argument, so we'll just be hearing from Attorney Johnson on behalf of Mr. Walter. Case number is 20AP0020. Panel is Judge Hensel, Judge Callahan, and myself. We have read the briefs. You'll have a full 15 minutes since the state has waived, Wesley. We just ask that you not use the names of any juveniles or victims in the case, if you would please. And we have read the briefs, and we're prepared to proceed if you are, sir.
Thank you, Your Honor. In this case, I think that this is one of the extraordinary cases. This court has ruled one of the exceptional cases where manifest weight, this verdict should be reversed for manifest weight. The evidence in this case does not in any way, shape, or form support the verdict in this case that was rendered by the trial court. In this case, my client was found guilty of 2 domestic violence charges, one against, I'll just say the boy, one is against the girl, and not guilty of threats, was found guilty of a minor misdemeanor disorderly conduct. Your Honor, the evidence is just not there, and I just want to start with, when you look at what the court said when the court made a ruling on this case, the court indicated that it was relying upon statements made by the boy and the girl at the time of the scene of the incident. So what happened was, the incident occurred, these individuals went to the IMG, that's where they went to speak with the police, and there were written statements taken at the time. In the written statement that the boy made at the time, he indicated that, first of all, that he wasn't scared at all. He indicated that my client and him had a confrontation, and that my client held his throat, that he took my client's hands off his throat, and my client and him screamed, "Do it, do it," and screamed it so loud that everybody should have heard it. Because the second thing that happened is the girl gave a statement that she was at the scene, and that the interesting thing about her is that she gave, not only did she give a written statement, she gave an oral statement. In the written statement, which you would think this would be there, there's no mention of the force that was used by my client in terms of striking her. Not any mention at all. No indication of the type of force. There was an oral statement made by the girl indicating that my client used 70% of his force to strike this girl. Now, why that's important is because when you review this case and you look at the cameras, you will see that my client is huge. He is gigantic. And the physical evidence does not in any way support what the boy says, doesn't in any way support what the girl says, any way, shape, or form. What the evidence supports is what my client testified to. My client testified never spoke with the cops. The police didn't speak to him at all in terms of asking him what happened or anything of that nature until only after they had arrested him and he was in jail in Wayne County. And he didn't speak to him at that time because they had already made their decision. And they made the decision, as testimony was, you're reading the transcript, they made the decision on the fact that they talked with Jennifer, they talked with the mom, they talked with the child, and the boy. Now the mom was there during the time that these written statements were made, and she, at that time, there was EMS individuals who looked at the children. Nobody took these children to the hospital. Nobody indicated that these children needed to go for further evidence. There was EMT there. The mom said, "Hey, if this is my child, I'm concerned about them. I would have taken them to the hospital," and she didn't because they weren't hurt. They weren't hurt.
Did they note any bruises, cuts, those sorts of things?
Your Honor, at the time there were the boy indicated that any bruises that he had on his face had dissipated. And that's why that's so important, because what he testified to is that my client had choked him. Okay, choked him, 2 hands. My client's an electrician. Choked him with 2 hands. No fingerprints, any way, shape, or form on any photos. And no photo note when they took photographs of the girl. No 70% injury that my client shows, or injury of that nature. Nothing. Wow, I do recognize that trial courts have some discretion in terms of making credibility decisions in terms of witnesses and evidence, and I think unfortunately I've seen some of the cases of my cases that I can, but that doesn't mean that in a case when there's a manifest injustice, when the trial court makes a decision on the evidence and on the physical evidence and on the statements that is manifestly unjust, then that's one case that should be reversed, and that's the case that we have right here. My client testified that, if I could just get into some other issues.
Your basis on that is the lack of evidence of injury.
Yes, Your Honor. I mean, one of the issues about that, there was certainly no medical records introduced in this case. Nobody came in from any of the medical providers. The photographs that were seen that were taken, if you look at, there were 3 photographs taken of the boy, a photograph of the girl. The photographs were very slight. It's even hard to even see. And one of the things was whether or not you actually could see an injury on the boy. The boy said that any injury that occurred had dissipated. So no injury. On the girl, there was a slight thing, very, very slight, Your Honor. And what my client said happened in this case was that he got into a confrontation with the child, the girl. Okay, she was outside. She was putting logs against the house, and she slammed the house with some of the logs. And she had previously indicated to my client that she didn't consider him her dad, that she would listen to him. And on this occasion, my client went outside and just leaned up the side door, and said, "Hey, quit throwing stuff against the door." And she kept doing it. What she did next was she come inside, she told my client to blank off. So my client is in his house, it's his house, and she comes, hey, she says, "You can't come in this house speaking like that. Totally disrespectful." And so when he goes around and just says, "Hey, I told you, stay out of this house. You can't come in this house. You're disrespecting me, this house." And that's kind of where there was a contact, and my client testified to that. But it wasn't domestic violence contact. There's no knowing, nothing of that nature. It's not a domestic violence case. It's not a domestic violence situation. Moreover, my client testified with respect to the boy that if it was a self-defense situation, the boy came in after the girl did. The boy came in and went after my client and started swinging at him. And my client just put up his arm so that he could stop him. And then at that time then tried to stop him and put his arm up and grabbed him by the shirt and just held him. And that is where
Did you raise self-defense down below?
Your Honor, it was
at the trial.
It was Your Honor. I do want to speak about that in terms of things that were raised at the trial and raised at the thing. It was not raised. It was said in terms of the closing argument, but there was no specific instruction in terms of in terms of that, nor was there any specific instruction on parental discipline of that nature. And this is why the case is such. And there's also, if I go into ineffective assistance in counseling, one of the people who did not testify in this case were the EMS workers. These are the individuals who didn't testify that nobody was hurt.
Okay, before you get there, are you saying that the failure to ask for a jury instruction on self-defense and raise that, is that part of your ineffective argument?
Yes, Your Honor.
Okay. Go ahead, I didn't mean to interrupt.
Yes, Your Honor. And also with respect to parental discipline, that's part of my argument too. and the fact that they didn't call the EMS worker to testify at the trial. Didn't call the EMS worker who saw workers, we'll just say workers, who were at the scene and saw the children after the incident, saw that the children were not taken to the hospital, reviewed that they weren't injured.
Well, you know, lack of, trial strategy is the hurdle there.
I understand that, but when it's like, when that goes beyond trial strategy, I think that kind of goes beyond, that to me, that goes to a question of whether or not somebody can be acquitted. And there is some case law on that. I did some research on that. There is some case law on that, that when you fail to subpoena a witness and have a witness come to trial who can acquit you, that is an effective assistance of counsel. Your Honor, I do want to go, if I could, just to one of the other issues I saw in this case, is that the court deemed the mom as a court witness. And in this situation, the court made on the record that I'm going to deem this child, the mom, the court witness, because I want to allow cross-examination. And this court has, in the past, indicated that this isn't like a free-for-all when you can name a court's witness. This court in State v. Watson indicated that if you're going to name someone as a court's witness, first thing you need to do is you need to submit an affidavit of why. The second thing you got to do is you got to talk about the court's witness at the time when you deem them to be the court's witness. So in this case, none of that's done. So you don't have an affidavit from the state saying why we're subpoenaing, why we want to name this person as a court witness. And the second thing you don't have, which this court required that you don't have a discussion with the witness on the stand about what's happening here. Why are you being deemed a court's witness? That didn't happen. The only thing that happened was the state called this mom to the stand. She took the stand and she testified, and the court said, well, we're going to allow cross-examination of you, and you're going to be the court's witness. That's it. That's improper. And it affected this case. First of all, it affected this case because I don't think the judge put any credence whatsoever in any testimony, even on the stand, even under oath, that the mom made in this case. The mom gave very important testimony on this case. She testified with respect to Andreas. When she saw Andreas just as my client had indicated. Andreas my client had his hand on his shirt against the wall, pushing it back. There was no situation with respect to him choking him or anything of that nature. What she doesn't testify to is whether or not Andreas came after my client before it occurred. But he totally discounts the woman's testimony.
Well, did the court find or treat her as hostile?
Yes. And
based on the fact that
based on the fact that she didn't want to testify, she wasn't going to testify. Well, it's hard to say because nothing's on the record with respect to what the conversation was with respect to the state and about what she was supposed to testify to. The only thing we have is her testimony, the statement that she made at the scene about what was going to happen. And at the scene, she indicates, which was later refuted because first of all, she testified that she didn't see it. And second of all, she indicated that my client grabbed the boy and struck the girl. And both of those statements were refuted. Because first of all, she testified that the boy, that she did not see the boy get struck like that. And she only reiterated what Angelina said to her. And because, and I'm just saying because what the record says, because the woman was not going to testify as, I don't know how she was going to testify. And that's the problem with the law, is there's no indication really in terms of, well, she's going to be a witness that is going to be against you, against the state, or against a party. And it can be any party, against any party. There's nothing on the record to say what that means. And it was devastating, Your Honor, I'm sorry, with respect to,
No, I just said you have about a minute left. I didn't want to
with.
tie you up with my question.
Your Honor, this is one of those extraordinary cases. This case was abused by was started off against against the defendant, and when the court made that ruling about, or was going to let that woman testify as a court's witness, the case went bad. This is a case that the evidence does not support in any way, shape, or form what the judge found. And it obviously is sufficiency to, Your Honor. Thank you.
All right. Well, you have 10 seconds if you want to say anything else.
No, thank you.
All right. Any questions that should have asked the court? No. All right. Well, thank you for your argument today. The court will take the matter under advisement, issue a decision in due course. Of course, you'll receive a copy on the day it's released. We'll send one out to you, and you can also find the decision on Supreme Court of Ohio's website. We appreciate you coming down and arguing today.
Thank you.
The court will be in recess, and I've lost the date for our next argument. Judges, do you have that?